Welcome, viewers. The law women thought still existed. The law women thought still existed. Most Australian women have never read legislation. Most Australian women have never studied legal architecture governing their protections. Yet, many assume they know where they stand. And that assumption creates confronting questions. What if the law you believe protects women is not operating in the way you think it is? And before asking what changed, shouldn't we first ask what existed? Because the society cannot understand the consequences of an amendment, 2013, until it understands the purpose of the framework that come before it. The original legal architecture was not designed to create women. It was designed to recognise women post-2013. Parliament did not invent biological sex. Government did not invent biological sex. Courts did not invent biological sex. The law recognised a reality that already existed and attempted to protect interests arising from that reality. And that distinction is the foundation of everything that follows. Well, it's supposed to be anyway. The original framework emerged from a straightforward principle. Women experience disadvantages, vulnerabilities, and responsibilities and realities connected to biological sex, pregnancy, motherhood, female privacy, female safety, female vulnerability. And the law sought to prevent unfair treatment while preserving protections connected to those realities. And the category being protected and the reason for protections were aligned. They were in parallel. Women were protected because biological sex mattered. The boundary existed because biological sex mattered. And the governing characteristic matched the purpose of the protection. And that produced clarity. Most women understood what the category meant. Most men understood what the category meant. Most institutions understood what the category meant. Most organisations understood what the category meant. And the framework was not perfect. No legal framework is. But the principle organising it remained relatively clear. If a protection existed because biological sex was relevant, then biological sex generally governed the protection. I'm going to say that again. If the protection existed because biological sex mattered, was relevant, biological sex governed this protection. It was governed by the fact of biological sex, not people with mouths and what they demanded, not women demanding things. It was just governed as biological sex governed the protection. Excuse me. Now, that certainty rarely attracted attention because certainty rarely does. People tend to notice instability, not stability, yet stability performs an important function. It allows people to organise their behaviour around predictable expectations. Now, women knew what category was being protected, and so did men. Right? It was a biological category. It wasn't a category somebody made up that just fell out of the sky. It was there all along. And institutions knew what category was being protected. The public generally knew what category was being protected. And because they knew, the governing principle largely remained visible until it became contested. And that's where many women believe the modern conflict begins. Not with a court case, not with an activist, not with a protest, but with uncertainty about whether the original governing characteristic still governs the boundary. Because once uncertainty enters the category, 2013, uncertainty eventually spreads beyond the category itself, into institutions, into organizations, into policy, into behavior, into trust. So let me close this session with a statement. Before Australians can decide whether the legal framework should have changed, they must first understand why the original framework was constructed the way it was. And the original architecture recognised women, biological women, as a protected biological class, and organised protections around that reality. And the central question of this series is whether the governing principle remained intact or whether something more fundamental changed.